Hi, welcome to our broadcast today. It is Tuesday, August 18, 2015. Lester Perling and I are in the Gassman Law Studio. We're here drinking Bloody Marys and eating cucumbers and talking about healthcare law. Thanks for joining us. Janine in my office is going to have a special announcement now.
If you did not receive the PowerPoint outline by email today, you can download it off of the GoToWebinar box that pops up on your screen. One of the options says Handout, and there'll be a plus sign next to it. If you click on the plus sign, it will open up the dialog box, and you'll see the PDF of the PowerPoint outline for today, and you can click on that and download it or print it.
And you can always email us for questions, and you can always email us for further information. You've got Lester's email address there. You've got my email address there. And I'll remind you, on Saturday, September 12th at 9:30 a.m., the 10 biggest mistakes that successful parents and grandparents make with college and high school students, with a counselor, Molly Carey, who's going to have some really insightful information. Wednesday, the 24th, 12:30 and 5 p.m., the biggest legal mistakes business owners and investments make, with me. Thursday, October 1st, some sophisticated income tax exit strategies for various tax situations with Steve Gorin. Saturday, October 3rd, failure to launch, how to handle a 20-something-year-old without a solid career path, again with Molly Smith. And then Wednesday, October 14th at 5:30 p.m. and 5 p.m., conventional and advanced estate planning techniques to minimize taxes and pass on your wealth. Lester, welcome to our webinar. Thank you very much for attending. You want to give people a little bit about your background? There's 3 or 4 people here who I don't think have heard you before.
Sure, Alan, thanks. I definitely want to attend that seminar on how to exit having to pay income tax. I assume that's what that is about, correct?
That's what it's about. Yeah, absolutely.
No more income tax. Excellent. Yeah, I'm a board-certified healthcare attorney with Crotty and Cassel. I'm in the Fort Lauderdale office. Been doing this for, scary thought, over 20-something years. I was a hospital administrator for 10 years prior to that. And this is what I do full-time, healthcare law, mostly in the compliance and fraud and abuse world, but generally as well. So that's enough about me. I think that's everything, right, Alan?
That's good.
So we're going to talk today. We only have slides on state law, but I wanted to talk first a little bit about one important change in federal law as it relates to Medicare, which maybe everyone has heard of, maybe hasn't heard the details, which is the repeal of the Medicare Sustainable Growth Rate, which was the provision in the Social Security Act governing Medicare that basically resulted in significant reductions each year in payments to physicians had Congress not intervened each year on a year-by-year basis to change that result. These reductions could have been as much as 20 or over 20%, and every year Congress had to intervene to just for that year because they could never get their act together to do something permanently. They finally did this year. There's sort of, I'm told by people in Congress, sort of a little bit of a new era of cooperation and some annoyance with the lack of ability due to partisan wrangling to get anything done. Even though this was something everybody agreed had to be done, they still couldn't do it for several years, but now they did. And so what this basically does is it creates, for the next 5 years, a sort of stable fee updates. So for the last half of this year that we're now in, there's a fee increase of 0.5%, and then there's a 0.5% per year increase in physician fee schedule in the years 2016 to 2019. Then in 2019, there's a new incentive payment system that will be put in place, which is called the Merit-Based Incentive Payment System, or MIPS, is what people refer to it as. And it replaces and consolidates the 3 existing incentive payment programs, which are physician quality reporting, value-based payment modifier, and meaningful use of electronic health records. And the payments after this date, starting in 2019, will be based on whether physicians either participate in MIPS or an alternative payment mechanism like an ACO, a medical home, some form of bundled payment arrangement, or any other approved mechanism, which has to involve some financial risk to the physician and also has to involve a quality measurement component. And depending upon whether or not physicians participate, and then if they're in the MIPS program, how they rate on a 0 to 100 scale will ultimately determine how much they're going to get paid by Medicare. And so basically, from 2019 to 2024, the system's going to be an incentive-based system to some degree. And then after that, and well, particularly in 2026, things start changing again. The details are not all certainly worked out. But it's going to be very much moving from if you do the work, you get paid with some possible incentives, to if you do the work, what you get paid will really depend on your performance, what program you're participating in as a physician, et cetera. It's a fairly complicated statute, but it definitely drastically will change how physicians are paid after 2019. Things will stay, assuming there's no other changes, which there could be, so fairly stable as we are today, except for those 0.5% updates and with the existing incentives that are in place. But at least the primary thing the statute did was to eliminate that risk of significant payment reductions, which was both a nightmare for physicians as well as a nightmare for the people who administer the Medicare program, and for Congress, who had to fight about it every year. So that's a big change. The Act did some other things as well. For example, it expanded the public availability of payment data for physicians. It adds some immunity for physicians who participate in quality programs by prohibiting failure to meet all standards as being used as evidence of as substandard care, or also failure to meet Medicare guidelines as evidence of substandard care, and also requires that electronic health records be interoperable by 2018, meaning no matter what vendor you buy from, as a physician practice, the systems have to be able to interact and speak to one another, and there can't be any roadblocks to that. And then there's some other little things in that statute, but I wanted to mention that on the federal level because particularly for physicians, that's obviously some important legislation. So turning to state law, and Alan, I don't seem to be able to control the slides, so we'll start with this one, but I can't do it. So experimental treatments. Before I get into that, one of the things that I wanted to mention was what's important with regard to the Florida legislature over the past 2 or 3 years is its inability to pass any bill that expands the scope of mid-level practitioner usage in the state or scope of practice, or further addresses telemedicine and telehealth. I mean, both of those issues are really critical issues for the healthcare system going forward in the coming years and decades as more people have access to healthcare and there are fewer providers to provide the healthcare. And so those types of stopgap measures become critical. And there have been bills in the last few years that would expand in Florida the scope of both of those that really haven't gone anywhere, probably primarily due to lobbying by the Florida Medical Association, who, for reasons that are probably obvious, don't like those bills. At the end of the day, the legislature will end up doing something, but what that will look like, I don't know. But I think their failure to act in those two areas is as important as sort of what they did act on. The last legislative session, as you might recall, was fairly dysfunctional. and actually ended early when the House of Representatives unexpectedly put down the gavel and all decided to go home. And that was really some political maneuvering within the legislature, because the House didn't like what some of the things the Senate was up to, even though both are both Republican-controlled chambers. So when they left, there were a lot of bills left hanging, including health care bills, but some things did get done, and these are some examples. So one of the things that got done is this bill commonly known as the Right to Try Act, and basically what it does is allows patients with terminal conditions as defined by the statute and who meet other requirements contained in the statute to be able to use a drug or product or device that is still experimental, has not yet been approved, but has successfully completed phase 1 of a clinical trial or of its clinical trials. And there's obviously a lot of detail laid out in the bills. So it allows the physician to prescribe those drugs or products for the patients who qualify for them. And then if that occurs, there's some protection for those practitioners, as you see here. Number one, a licensing board can't take action against the physician's license for recommending any of these items. Both the manufacturer and physician have some immunity to liability for the use of the item to the patient, and also the heirs, but also the heirs are not liable for patients' debt related to the treatment. Insurance companies are not required to pay for it unless they're already required by law to pay for experimental treatments in certain very limited situations. But anything that would otherwise be tried or prescribed as a result of this act does not have to be covered by insurance. It would be an out-of-pocket expense. Insurers could cover it if they choose to do so, of course, but are not obligated to do so. So this probably, I'm not sure how much benefit this will be, but it certainly gives patients hope. And there's a very long FDA approval process that keeps drugs with a lot of promise in the pipeline for a long time before they're approved. So this could prove to have some benefit if used appropriately.
This is going to help a lot of people in a lot of ways. That's really good news.
So, next slide, Alan. This bill is not that hugely important. Relates to HIV testing both in healthcare settings and outside. It adds a definition for those two that you see parts of the definition here. A healthcare setting is any place that is devoted to diagnosis and treatment. Physician office isn't listed here, but obviously is included in that definition. And then a non-healthcare setting is defined as sites that do testing, but don't do treatment. They're not for diagnosis. People can go to a lot of different sort of social service places to get tested, and all kinds of places offer testing. So this distinguishes between the two, and it makes it clear that informed consent is required in either type of setting, and that the patient has the right to decline testing in either site as well. And it amended certain notification requirements before the test is administered. One of those is that the patient has to be told that the result will be reported to the Department of Health, and that if they don't want it reported, that they can choose to be tested in what are called anonymous testing sites, and have to be given the names, locations, phone numbers of those sites if the patient chooses to be tested anonymously. So that's the primary thing that this bill does. It amends the existing HIV testing bill and adds some of these provisions. So the next bill relates to the ever controversial topic of abortions, and there's an error in this slide I'll point out to in a minute. A lot of what this bill does is it requires physicians to provide specific informed consent information to pregnant women who are seeking abortion. The second bullet point has the typo in it. It should say requires that the physician performing the abortion or the referring physician, not and the referring physician. So when they're talking to the patient about the risks of having the abortion and what's required to be explained to the patient under the statute, it can't be by phone, it can't be by a physician sort of surrogate, if you will. The physician has to be in the room with the patient. And this information that's provided orally, and then there also has to be a written consent, can be done no sooner than 24 hours prior to the procedure being performed. So what the legislature did here was, instead of explicitly sort of creating a 24-hour waiting period by saying that the patient has to wait 24 hours from the time they request the abortion, they did it in a little bit of a backhanded way, although not that backhanded, by saying that the informed consent information can be given no sooner than 24 hours before the procedure is performed. And then there's some exceptions for those waiting period that are listed here that are sort of typical exceptions. So those are the key elements of that particular bill that amended the existing statute related to abortions. The next bill, which I find kind of interesting, is, although it doesn't do a whole lot, clinical laboratories can now accept orders or requisitions for laboratory testing from consultant pharmacists or doctors of pharmacy. So all this bill did was say that add to the list of people who could order clinical lab tests sort of those two professions or degrees. It's, I guess, not entirely clear to me when a pharmacist would order a test, a lab test, but I presume that there must be some, because I also presume that this was the result of somebody's lobbying efforts. But it really isn't very apparent to me when this would be used. But nonetheless, they can do it now. I doubt insurance companies would pay for it if it's not ordered by a physician. But nonetheless, the labs could accept an order from a pharmacist. I don't, perhaps if a pharmacist wants to do a drug screen before they dispense a drug, I don't know. But in any event, that's what this bill does.
Very interesting.
Next bill. I'm sorry, Alan.
I said very interesting that we evolved to having pharmacists practice medicine.
Well, there still would be an issue of what they could do within the scope of their licensure. Florida does allow pharmacists in certain limited circumstances to dispense without a physician's order. Maybe, this could interplay with that. The next bill, which I find particularly uninteresting, relates to public health emergencies. It basically adds a provision that allows law enforcement officers to enforce isolation and quarantine orders, which I gather before this bill they did not have that authority. It was officials from the Department of Health or local health departments, and probably this bill was a result of the whole Ebola business and people being quarantined and leaving quarantine and whatnot. I'm not sure that was a problem in Florida, but I assume this bill arose from that. It adds definitions of what isolation and quarantine respectively mean, and like I said, adds that authority to law enforcement. The bill stated it was to fulfill an important state interest, and I presume this was a response to the whole Ebola mess that occurred several months ago. The next bill, I think, is interesting, and it's a little bit, I guess, to me, somewhat of a sad statement about where we're at in society in terms of the use and abuse of opioid drugs, narcotics, those drugs that are commonly prescribed or dispensed by pill mills and which now are becoming a major cause of death and emergency room visits. And essentially what it does, it allows now any practitioner who can write a prescription for this class of drug to prescribe and dispense emergency opioid antagonist drugs, which are defined in the statute in terms of the class of drugs, for emergency purposes. And it's interesting, the drug can be prescribed to a patient, meaning, I guess, the person who's using the drugs, but it can also be prescribed to the caregiver, which is defined really broadly as a family member, friend, or person in a position to have recurring contact with a person at risk of experiencing an overdose. I assume that could include the person's pusher, I don't know, but in any event, what it's designed to do is to be able to allow very quick treatment of these patients who the individual who's going to be administering the drug has reason to believe has taken an overdose of one of these drugs, because they're very effective, but they have to be administered very quickly, and an emergency response may not be available even by the local EMT service in enough time to save the patient. And I guess the presumption is if your spouse is addicted to oxycodone and you know that, and they're unresponsive, you can pretty well bet it's an overdose, and or at least have a reasonable basis to believe so, and go ahead and administer one of these drugs. And probably, if you're wrong, it's not going to damage the patient irrevocably, so the risk was sort of outweighed, the benefit outweighed the risk, rather, of allowing this to occur. And as you can see, there's some immunity established for civil liability to practitioners that prescribe and dispense these drugs, and it doesn't create any sort of duty or standard of care with regard to the prescription or dispensing of the drugs or administering the drugs. So if someone administers the drug and they're wrong, or the person maybe is allergic to the antagonist or something, there would be some immunity from liability. So, like I said, this bill, I think, to me, it's kind of surprising the legislature went this way, and it's a little bit of a sad statement with regard to the state, like I said, of where we're at in society with regard to the use or abuse of these drugs, but there it is. The next statute amends the laws governing healthcare surrogates, and basically allows someone to designate a healthcare surrogate and have that person have decision-making ability at any time, even when they're still competent to make their own decisions. However, if they are competent, if their decision would override the surrogate. So I was trying to think how this would play out, but this means if I appoint a healthcare surrogate, and in my appointment I say they can even make a decision if I'm still competent, that the healthcare provider really, well, I was thinking, well, that means they could ask the surrogate and not me, but the law actually says that you have to, if the person's competent, you have to advise the person of all the facts related to the care, although they then could rely on the surrogate to make the decision if the individual, the patient, chooses not to do so. I'm not sure exactly in all the situations that this would play out, but nonetheless, it does allow the surrogate to make decisions in those circumstances. It also provides some expanded permissions for the surrogate with regard to being able to consent to care or get health care information for minors. But the bill or the statute is very clear that any principal who is still competent, their decisions control over the surrogates if they conflict. So again, that's what that bill does. There's quite a bit of revision in the bill that you should look at if you're interested to get the full scope of it, but that's basically what it does.
And we will schedule another webinar just to look at healthcare surrogate forms after the new bill. This can be important when in a situation where the doctor walks into a room and he doesn't know or she doesn't know whether the patient's competent or not, but their child is there, there's the healthcare surrogate. The decisions can be made without having to determine competency. So this should be good for a lot of people.
But if the patient says, well, wait a minute, I'm here, then they have to listen to the patient.
Right. Makes sense.
Yep. So what this next bill entitled Insurance Fraud does is it amends the healthcare clinic licensure statute. And, you know, this is basically at the urging of PIP, personal injury protection insurers and people from the Office of Insurance Regulation. But it basically toughens the penalties if a clinic operates without having a healthcare clinic license when one is required. It basically says that their charges are unlawful and that if they submit a claim, it's theft, even if the charges weren't paid. So if I'm operating a clinic, I should have been licensed as a healthcare clinic. I wasn't. I submit a claim. The insurance company catches it and realizes, hey, you're supposed to be licensed. I'm not paying your claim. The mere fact I submitted the claim is considered to be theft and is a criminal act. It changes unlicensed activity in some circumstances from a misdemeanor to a felony, and it also creates an affirmative requirement on healthcare providers, people licensed by Chapter 456, who have knowledge of an unlicensed clinic to report it, or they could be subject to discipline against their license. So it's, you know, the legislature continuing to kind of tinker these bills to, in an attempt to protect PIP clinics from claims from clinics that are operating unlawfully. So it definitely ups the ante for those providers who are out there who, you know, should be licensed as a clinic but are not licensed as a clinic. And those folks who aren't sure really need to check that out in order to avoid some of these potential significant liabilities.
But typically, you need to be licensed as a clinic if you're not owned almost entirely by physician or physician-permitted family members, correct?
Yeah, it's actually 100%. So even 1% by a non-physician or a non-immediate family member requires licensure. There's other exceptions, of course, but that's probably the principal one that applies to most folks.
So as soon as the insurance carriers find out that the doctor's office was inadvertently owned 5% by a non-physician, they go back, they want all their money back, and they're going to report this as a criminal activity.
Yes, and you can fully expect the PIP carriers to be aggressive about it. Other insurers are, you know, certainly far less aggressive than the PIP carriers, but for those practices that bill PIP carriers particularly, although other insurers could as well, you know, you really need to be mindful of this. So the next one is probably its last, and it's the least interesting. Physicians, somewhat relevant to physicians. It just requires that if a patient is admitted to the hospital on observation, 24-hour or 48-hour observation status, rather than as an inpatient, that certain services be documented during the observation stay, and that they're included in the discharge papers. And it requires hospital to inform patients about their status, because sometimes patients don't know their status, and then they have issues with the bill. They thought they were admitted to the hospital because they stayed overnight, but really they were not ever admitted. They were in an observation status, and that can change their payment obligation. So that was it.
Okay, Lester, thank you very much. We sure appreciate all the help you've given us over the years. You are the healthcare lawyer of the universe as far as we're concerned. And it always amazes me how knowledgeable you are and how efficiently you're able to find answers to some arcane and very confusing situations that we find ourselves in. So thanks again for all of that and also for attending today.
All right.
Okay, attendees, please send Lester all your hard questions, all your praise, all your comments, and we'll see you again for another webinar soon. Have a great afternoon, and may the rest of your time be billable.